So we are now just weeks, if not sooner, away from what could be one of the most important Second Amendment decisions by the Supreme Court since they issued Bruen. The court is expected to issue its new ruling in the case Woolford versus Lopez before the end of this term, which will be late June, early July. This new ruling will build directly off of Bruen and also address state defiance that has developed since that ruling. And this is not just another Kerry case, because other major Second Amendment challenges like the Benson versus DC case are now officially on hold while courts wait to see how the Supreme Court is going to address this issue. That means that the Supreme Court may be about to answer questions that could impact other issues like magazine bans, carry restrictions, sensitive place laws, and also potentially hardware cases, all because of how the Supreme Court applies Bruen and how they say courts need to continue to do this going forward. So let's break down what is now happening. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also hit the like button. That just tells the algorithm that you appreciate this content, and so it should share it with more people. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. So if you're interested and you want to check them out, you can do so using the links down below. And right now, until the end of July, you can use my code ARMSCHOLAR to get $50 off of your individual sign-up fee or $25 off the family fee. But again, remember, that's only for a limited time. Now, as I mentioned in the intro, the Supreme Court is expected to issue its new ruling in a case called Woolford versus Lopez, and that will happen before the end of this term, so in just a few weeks, but it also could come sooner. The timing is important because the court traditionally finishes its term in late June, early July, meaning we're now entering that kind of critical decision phase of this season. And Woolford may end up becoming one of the most significant two-way cases and rulings that we've got since Bruen, not just because of the specific law being challenged in this case, but also because of what the court may say about how Bruen should now be applied going forward. Woolford involves Hawaii's response to the Supreme Court's ruling in that 6-3 ruling in New York State Rifle and Pistol Association versus Bruen. After Bruen struck down New York's May issue CCW licensing system, Hawaii enacted a new law in response, creating what many gun rights advocates actually view as a default carry ban. Under Hawaii's system, concealed carry permit holders cannot carry firearms on private property that's open to the public unless the property owner gives express permission beforehand. That completely flips the traditional rule on its head. Historically, carry is allowed unless a property owner says no or posts some sort of sign saying that concealed carry is not allowed at this location. Hawaii's law effectively says that carry is prohibited everywhere unless the property owner says, yes, you can carry at this location. Now, the Ninth Circuit on review upheld this Hawaii law, and now the Supreme Court is reviewing that decision by the Ninth Circuit. Now, on the surface, this might sound like a property rights dispute, but this isn't really what's driving the case. The bigger question is whether states can effectively nullify the right to keep and bear arms through creative regulation and trying to change these rules because they did not like how Bruen was ruled on. The challengers argue that if the government can simply declare that, all private property open to the public is off limits, well, then the right recognized in Bruen becomes largely meaningless and, two-way rights essentially go away. Because they argue a right that exists only on paper is not much of a right. And that's the concern the court appeared very focused on during the oral arguments in this Woolford case. During the oral arguments, several of the Supreme Court justices appeared skeptical of Hawaii's current position. The court repeatedly questioned whether Hawaii's law functions as a near total carry ban. In practice, Hawaii claimed that there are ways that you can carry, locations you can carry, but the Supreme Court and a lot of the justices on the Supreme Court seemed very skeptical of that position. There were also questions about Hawaii's reliance on historical analogs. Several Supreme Court justices challenged whether the state was relying on historical laws that were either irrelevant, discriminatory, or fundamentally different from the restrictions being imposed by the state today. The central concern seemed to be whether Hawaii was genuinely protecting property rights or whether the state had simply created a workaround because they did not like how Bruen was ruled on. Based on the oral arguments, I still think that Hawaii is likely going to lose this case. The real question isn't whether Hawaii loses in my mind. The real question is how broadly the court writes this opinion. The Supreme Court could issue a very narrow opinion focus specifically just on Hawaii's law. Or the court could issue a broader opinion, reinforcing how Bruen's text, history, and tradition test must also be applied going forward because they've seen the response of the lower courts after Bruen. And that's where cases like Benson actually enter the picture and where this ruling in Woolford becomes very critical. Recently, the DC Court of Appeals granted a rehearing en banc in the Benson DC magazine ban case. So if you remember, Benson originally produced one of the most kind of significant magazine ban rulings that we've seen essentially since post-Bruen. The panel struck down DC's magazine ban and vacated several related convictions. But then the full court in DC stepped in and the original opinion was actually vacated. And now the case is being reconsidered en banc, but at least for now, the court has actually put a hold on that rehearing. It was recently put on hold because the court there wants to wait for the Supreme Court to issue their ruling in Woolford and Homani, and they want that type of ruling and they want that analysis before they move forward on the Benson case. Now, that's a pretty strong indication that the DC Court of Appeals actually believes that Woolford may substantially affect how Second Amendment cases are analyzed moving forward. So this is the part that many people are missing or maybe just don't see. Woolford isn't a magazine ban case or a hardware case, but it may tell lower courts how aggressively they must apply Bruen going forward. And that's exactly why the Benson court is waiting on that opinion. The DC Court of Appeals is recognizing that the Supreme Court may soon provide additional guidance regarding historical analogs, sensitive place restrictions, public carry, government burdens under Bruen, and how courts should evaluate modern firearms regulations. And all of those issues matter in Benson and could actually impact the outcome of that ruling. So when Woolford comes down, there are a few things that I'm actually going to be looking for to see, what is the broader impact of this decision. First, how strongly the court reaffirms Bruen. Second, how demanding the court is when evaluating historical analogs. And finally, whether the court writes broadly enough that the decision there can be applied beyond just those carry restrictions. Because if the court writes a strong opinion reinforcing Bruen and actually maybe even addressing a lot of the lower court defiance, that could immediately impact cases involving magazine bans, rifle bans, sensitive place restrictions in other states, carry restrictions, and other types of two-way challenges that are moving forward. So we're now entering one of the most important periods of the Supreme Court term. The Woolford decision is expected here within, at the latest, the next few weeks. And other major two-way cases like Benson have been put on hold while courts are waiting to see how the Supreme Court addresses these cases. That means that Woolford may end up having consequences far beyond just Hawaii's concealed carry law that they passed after Bruen. The ruling could shape how courts are supposed to analyze Second Amendment cases nationwide and directly influence the future of magazine ban litigation moving forward in cases like Benson. And with the Supreme Court's term rapidly coming to a close, we likely won't have to wait much longer to get an idea of how the Supreme Court wants to handle two-way cases going forward and see potentially the broader impact of that ruling. So that's where this currently stands. We're currently waiting for Woolford. It's going to be coming very soon. And then we're going to see, what is potentially the broader implications of that ruling. So as we get more information, as it develops more, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.